Podcast is a much newer industry. The host is so central to the success of the medium that I don't think you get away with unfair deals as much as you maybe do in other industries. If the guest gives their informed consent, knows they're being interviewed for a podcast, and gives their informed consent and participates, you don't need a release to then use that interview. First Amendment considerations. So a lot of this is, when you're reviewing the script, it's separate from the copyright issue. Is my client going to get in trouble for what's being said in the podcast?
My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speaker, Alexia Bidat. Alexia's clients range from podcast and audiobook production companies to documentary filmmakers, TV producers, and studios. She supports content creators from early deal-making stages through to development and distribution, and as clearance counsel. Alexia leads the podcast and audios team at Claris. She works closely with founders, heads of audio, and producers across their slates, both in business and legal affairs. Her practice includes negotiating and drafting host deals, slate/first look agreements, distribution and sales arrangements, IP development and adaptation, and all forms of licensing and releases. She seeks to help content creators develop their IP responsibly and adapt to evolving technologies in the audio industry. As a binational herself, Alexia also works with non-US production companies on US-facing deals. The webinar presentation that you're about to watch will be approximately 1 hour, and Alexia will be taking audience questions once the presentation is complete. Now, without further ado, here is Alexia to discuss Podcasting 101, advising clients in pre-production, production, and distribution.
So hi, everyone. Thank you for joining, and thanks, Nina, for the lovely intro. Typically, and as you all know, we're all lawyers here. I don't have to say this. This is all for educational purposes, but I really put it here because especially in the podcast industry, and I'll turn to slides about that, depending on who you're representing, you're going to take a different view on, obviously the different deal points here. And this is going to be while the topic is advising clients in the podcast industry, we're going to look mostly, I'd say, from a transactional point of view, the deals that you'll encounter when you're working with podcast clients. So truly, depending on, which side you're on of the negotiation, it's really going to be very different. So it's, I think, an important disclosure here. I won't say much about myself because Nina did a very kind intro, but here are my details on the screen. Feel free to be in touch if you have any questions after. So this is it's a topic that I personally, as Nina mentioned, I love. I work with a lot of podcast production companies. I think it's a very fun area for lawyers to practice in. And I do mean fun because unlike a lot of entertainment, film, TV, where there's very set precedents, very, custom and practice over decades and decades and decades. Relative to that, podcast is a much newer industry, and therefore you have, I would say, more leeway as an attorney to be creative, to come up with different business models, to think about different business models. And also, it's an industry where the host is so central to the success of the medium that I don't think you get away with unfair deals as much as you maybe do in other industries. I don't mean you as in the attorney, but just the industry doesn't. And so you really have to be creative to get to a deal that everybody at the very least feels somewhat on board with. So we'll do, there'll be an overview of all that kind of work and what you may be brought to do as an attorney advising in this space. And like I said, we'll focus especially on the deal-making process and a little bit as well on clearances. So the objectives are there on the screen, and I think you're, familiar with them if you've signed up or if you're watching this. But we'll, look at the legal processes with creating and distributing podcasts. We'll look at the different types of agreements and identify some potential issues that are maybe a bit more specific to podcasting than if you were negotiating just another different type of content. In terms of the agenda, we'll go through a little bit at a macro level, sort of podcast, how they come to life, a little bit on that, the different rights elements in a podcast. And then we'll go through the different kinds of agreements you might encounter. We'll then dig deeper a little bit on a bit of contract specific clauses. And then briefly on clearance issues, what you may be advised to do if you're also clearance counsel on a project. And then we'll do a bit of, if there are Q&As, we'll wrap up. And yeah, that'll be that. All right, so let's get it going. So the life of a podcast, how do really podcasts, how do they start? And this is relevant here because depending on how the show starts, your role as the attorney is probably going to be different, right? So the shows are typically pitched in a number of ways. They may start with the agents that are going, and the agents represent either talent or they represent production companies. In some cases, they may represent the actual network or the platform, and they'll go and pitch shows. So that happens sometimes, and you may be asked at that level, at the maybe not the pitch, but as soon as there's interest, to step in a more business affairs capacity and to help advise your client, to work in tandem really with the agents on advising on the deal terms. So if you're doing that, having a really, an understanding of the industry, and it's a very fast moving industry, and there's a lot of great trade publications that you can follow. But if you're sort of getting involved early at that business affairs level, that's very helpful. Sometimes you just have individuals who are going to be pitching to different buyers, financiers, and you might be helping that individual if they don't really have an agent, not necessarily as an agent, but, supporting again, business affairs level. And sometimes the production companies are pitching to the buyers, and sometimes it's production companies are pitching to other production companies to split the costs of the production if they don't have a buyer yet. And that's where you may be brought to draft a co-production agreement where you're, probably representing one side or the other. So just slide is really just that, depending on what stage, you get involved, your role is going to be different. And a little bit briefly on how these, shows are monetized, and that's going to be important in terms of how the deal is structured. But there's, typically either if it's a production company and there's a buyer, whether it's Spotify, Audible, Wondery, fill in the blank, those places are typically often either they're funding the budget, which is where you see there at the top, or maybe if you look at the fourth bullet point, they're not funding it, but they're getting exclusive distribution rights, and they are giving you they're giving your client a minimum guarantee against those exclusive distribution rights. In some cases, like I said, it's going to be co-productions. It might be a branded podcast where a brand hires your client or you represent the brand to have a podcast that is giving information about the podcast. And typically there, it's going to be a work for hire. The production company is going to have their production expenses and costs covered, as well as typically charge a production fee, which is where they'll make their profit. And that'll be a line item in the budget. And there's all kinds of considerations there about what happens if your client's deal gets terminated. Do they get to retain their production fee? Sort of thinking through, because often in those positions, if you're just doing a work for hire, your client is doing it on a work for hire basis, the commissioning entity can, decide to stop at any point. So your role as the attorney there, it's important to think through, well, if they stop, and it happens unfortunately often. So if they pull the plug on this project, is the client protected? Do they retain their production fee? Do they retain it in full? Do they retain it prorated to the amount of weeks that they've been working or months? Do they get some, other fees? Are they recouping all of their expenses? So sort of thinking through what happens when it goes wrong, depending on how the show's monetized, is particularly important. There's a few other things. I think there's first look deals, which you may have seen in the news a lot, where there's one entity, typically a film or TV production, that gets a first look. They will be the first person that gets to turn the podcast into film TV. And often the money that they pay in exchange for the first look is what allows your client, the podcast production company, to develop new shows. I mean, there's different ways to structure it. This slide is just briefly here in terms of, if you think of the topic of this CLE, which is advising clients in the podcast industry, there is often this notion and this thought of derivatives, and derivative rights are hotly negotiated. What happens if it gets turned into a film TV show? If you're representing the production company, if it gets turned into a film TV show, is the production company somehow involved? Whether that's, do they get a share of the revenue from the film TV rights? Do they get an opportunity to be attached as executive producers? If you're representing the talents, the hosts, same question. So the derivatives are always a very important part of negotiation. I think there's maybe a little bit of a misconception that all podcasts turn into film TV, which is, of course, not true, but it's important to think about the what if and to have your contract that plans for that. So the different types of clients and agreements, and just before we get into that, I wanted to, I like this slide here, and often when I talk about podcasts, I talk about the rights layers. Sometimes it's, you can look at it as like a pie or like this a chart, because I think it's important to visualize it this way, to remember that in the agreement, just saying who owns the podcast is not enough, because what does that mean, right? You have the podcast is a bunch of things. There's the pre-existing content. So potentially, is this based on a book? Do you have the rights to whatever the podcast is based on? Then there's all the new materials, the script, everything new that gets created. Who owns that? The copyright and the recordings themselves, those files, who owns them? And the RSS feed is very important, because often podcasts are distributed through RSS feeds. So I'm sure a lot of you listen to podcasts. It's probably ad supported. They're free. You either listen to or skip through the ads. And those are distributed through an RSS feed that you subscribe to. And that's why you get a new episode pushed to you, notified when there's a new one. And there's incredible value to those feeds, because even when the podcast is done, let's say it's a podcast about, I don't know, the medical industry, and then your client doesn't renew for a second season, but then has a new medical focused podcast, you're going to want to be able to drop that podcast into the feed and tap into that audience that is somewhat interested in a similar thing. So the RSS feed, who owns it, and who gets to control it, is super important, no matter which side, right? If it's the entity funding it, they're going to want to own it, because even if they don't renew the podcast deal, they've now invested money into an asset, into the feed, that they'll want to drop other podcasts in. If you're the production company, a typical ask is that the production company, who has a bunch of their own projects, will want to be able to promote one of their shows in the feed. And if you're the host, you're going to negotiate very strongly to try and have the ability to take the feed and to keep making the show yourself if the production partner, the buyer, doesn't want to keep doing it. So everybody has different interests in it, and it always comes up as a topic. And so when you're looking through advising clients in this space, really thinking through and how all of these layers are addressed is important. And ownership doesn't necessarily mean everything. You could own the recordings, but the other party receives 25, 30, 50% of the profits generated by. So the actual ownership and the beneficial ownership are not always necessarily linked. And depending on the leverage you have and the negotiating power, I think thinking about ownership in that way is very helpful, because essentially the leverage often follows the money, or sometimes the audience and, the notoriety of the host. But typically, the party who funds the podcast is going to likely get away with owning it. But that doesn't mean that your client, who's the talent or the production company, necessarily has a bad deal. Because if your client shares 50-50 and all of the revenue, is attached to derivatives, has access to the feed, you can contract into, the benefits of IP ownership, even if you don't own the IP, which I think is sometimes a bit lost if you focus too much on ownership of the IP. So here on this slide, you see the different types of agreements you may encounter if you're going from all the way from pre-production through to distribution. I won't necessarily go through all of them there because they're on the screen, but the typical ones are you have host agreements, you have agreements potentially with the guests, and we'll get to later whether, how to advise clients about, do you need a guest release? What should it say? When do you not need one? What to do if you don't get one? That comes up all the time. And then during production, there's, all the materials releases. Are you using third-party material? Are you relying on fair use? We'll also turn to that later. The actual script itself, what's being said. If you think back at the slide I had at the beginning of the different ways the shows are monetized, depending on the party who's funding the show, and if one party's funding it and your client is producing it, typically the client producing it has a responsibility to deliver a fully cleared show. So when you're negotiating that agreement, if you're representing the party producing it and who's delivering it and who has the responsibility for it to be cleared, there's a number of things to think about, which I'll turn to a little bit later. And then you may also negotiate distribution deals, some of which are there on the screen. So like I said before, always thinking about who is your client, because if you're representing the production companies, if you're representing the platforms, you're going to want to get as many rights as possible. If you're representing the talent, typically you want to grant as narrow rights as possible because you want to retain the ability as the talent to do other things, right? A lot of podcast hosts are also maybe writers. And so the issue of the publication rights, who gets to write a book, who gets to decide, how is the revenue split for the book, who gets to put on a live stage production, who gets to decide if this is pitched as a film, TV derivative, who gets to be involved. All of those things are things which you want to look back on your agreement and be able to answer. So talent agreements, some things to think about. So if you are working on a talent agreement, whether you're representing the host or whether you're representing the production company that's collaborating with the host, there are a number of things to think about that comes up. Who owns the IP? So I went through that already. Again, like if you're the host and you wrote a book, then you're going to grant, and the podcast is about the book, you're going to grant a license to the book. Well, what kind of rights are you granting? Are you just granting the right to make a podcast? Are you granting the right to make a podcast and derivative rights? Are you reserving any rights? Are you retaining the right to do something, independently of the production company? So it's really thinking through the grant of rights if there's pre-existing materials. Derivative works, like I said before, if you're representing the party who's funding it or the production company, do you have the rights to then go and turn it into a film TV show? If you do have the rights, are you sharing that revenue with anyone? If you go and turn it into a film TV show, does the host have a contractual right to be involved, right? You get this question often where the agents that represent your clients will tell you, hey, we're shopping this project around. Can you just tell us what we need to do about the host? Do we need to tell people the host has to be involved? Like if Netflix is interested, are they going to have to just cut a deal with your client, or do they also have to cut a deal with the host? And being able to look back on the agreement and being able to get that answer clearly of, yes, the host is involved. The host gets to negotiate, her own deal, or no, you can negotiate on her behalf. What happens if the host can't close her deal? Can you move forward if she can't? All of those things are not always, but can be set out in the contract. Who approves creative and business decisions? This happens often, right? If there's a disagreement, who gets to decide? Typically, the business decisions are going to be led, or at the very least, the tie break will be for the party who's funding the podcast. The creative decision, there's typically a bit more flexibility there. And then when you're thinking about that, the approvals, this is going back to what I said before about who has the responsibility to deliver a fully cleared podcast. So if you're representing the podcast production company that's delivering the podcast fully cleared to, say, Spotify, but Spotify has final say, what happens if Spotify and their final creative say put something in there and then somebody objects to that and sues you and Spotify? Did your agreement say that you would indemnify Spotify for that? Or did you carve out that you deliver something fully cleared, but you're not responsible for things that are as a result of Spotify's tiebreak or their creative control? I use Spotify as an example here. It could be anyone, right? But sort of like I like to use the word thread the needle. You really want to thread the needle and think, you know, do things match and make sense? Is the party who's responsible for delivering it in a position to make a decision and thinking through like that? Who's responsible for clearing the content? You can be very helpful as an attorney, especially to your production company clients, by flagging if they're the ones who are responsible for clearing the content. That means they're going to incur legal fees in reviewing it. And have they budgeted for that in the production budget? Is the line item for legal sufficient? Based on your experience, like, should they be budgeting more, and sort of helping them with that? How the compensation structured? So how's the host getting paid? Is the host getting a flat fee? Is the host getting a percentage of the back end? So is the host participating in the revenue? And if you're representing the host and the host is getting 50% of all of the revenue, the profits, that sounds awesome. But how are the profits defined? Because there's going to be a whole waterfall of things that get deducted from the profits. And sometimes those waterfalls, in effect, mean that there's so much coming out of the top that your client's never going to see a cent, or may not, unless the show is widely successful. So not just negotiating the split, but how the net profits are calculated are equally important. Who owns the feed? I spoke about that earlier. Are there broad distribution rights? Are there limitations on how you can distribute it? Can you distribute it with a visual component? If you're representing the talent and they have an exclusive audio visual deal, then you're going to want to be careful that this podcast deal, any video component, doesn't run afoul of your client's other audio visual exclusivities. And what about renewals? What if the host wants to make a second season, but the buyer doesn't? What can the host do? Can the buyer shelve the podcast forever? Is there an opportunity to buy the show back? Is there a reversion? There's many ways to structure this, or maybe there's not. Maybe it's just the distribution entity, the funder funds it and decides what to do, and that's that. I mean, there's many different deals, but that renewal and what to do if the production company wants to renew, what to do if the host wants to renew, and thinking through, typically the only time you reopen an agreement is when things go wrong. So actually spelling out, the most clear, very clearly what happens when the parties don't want to keep working together is a bit uncomfortable at the beginning, but is, I would say, 80% of the time I get asked the question about a contract. It's, hey, we're moving away. We don't want to keep doing this with the host. Is that an option? Or the host, asking the same question. And it's when it's set out clearly in the contract, it makes it a lot easier. So guest releases. This is something you'll be asked to advise on often, which is, I'm doing an interview show. Do I need releases for my guests? And I guess there's two different answers there. There's the strictly legal answer, and there's the, I'd say, more business oriented question. So the strictly legal answer, and you may find some attorneys who disagree, but if the guest gives their informed consent, knows they're being interviewed for a podcast, and gives their informed consent and participates, you don't need a release to then use that interview in the podcast. The release, the question is more, there's that implied license to include it in the podcast. The release is more, well, what if you want to do other things? What if you want to include that interview in derivatives of the podcast? What if you want to use that interview to promote other unrelated podcasts that your client does? Like, the second you start to go outside of the bounds of what's just implied by participating in the podcast, that's where a release comes in handy. Another thing the release does is it tends to lessen the chances of the party saying, I didn't agree to this, I didn't know, I didn't realize, right? It's kind of hard to say that if you signed a release. And importantly, again, if you think back to, like I was saying, your client might be the production company that's delivering the show to the funding platform, and the funding platform requires you to have releases. Well, then in that case, separate from the legal, that's, a business consideration, you'll go and you'll try your best to get releases. If you do get releases, being very careful there as to what kind of restrictions you agree to, because anytime you put paperwork in front of a talent lawyer asking for them to agree to their client's name, voice, likeness being used in all kinds of unlimited ways, you're going to invite a lot of feedback. And I would say more often than not, you end up with more restrictions on how you can use an interview with, high level talent when you get a release because of all the contractual restrictions you've agreed to, than if you just go ahead and use the interview, right? Often they're going to ask to approve the interview before it's released. They're going to ask to approve the use of their likeness and promo. They're going to ask for, you to agree that you're not going to portray them in a derogatory or defamatory way. And that the request for approval is when you want to think about very carefully. And if you're representing the production company that's delivering this show to the funder, you don't want to go and agree to restrictions that you haven't cleared with the funder. And then when your client delivers the episodes, you want to make sure they deliver any restrictions so that the company who commissioned it knows when they receive the podcast what they can and can't do with every episode. And confidentiality, depending on who is going to disclose what, you might want the guest to agree to, not talk about the interview until the show is released. So there's all kinds of things you can put in a release, and thinking about how you define the scope of what it is. Is it just for the first season? Is it the podcast as a whole? Have you defined the podcast at the top as any and all seasons? So lots to think about when it comes to guest releases. For distribution, there's distribution agreements. Like I said before, you sometimes negotiate for a distribution deal where in exchange for getting distribution rights, your client's going to receive a minimum guarantee against the distribution rights that they're granting. You might negotiate sponsorship deals for your clients where you're, agreeing to a sponsor for one episode, all episodes, being very specific. It's not just we sponsor the podcast. What does that mean? Is it exclusively? Is it the entire podcast? Is it one episode? So specificity is key. You might be licensing the podcast to go behind a paywall. If you're representing the production company, think about, now the plan is to put it on a paywall. But if you've licensed all distribution rights to an entity that primarily is a subscription website where you have to pay, that's today, right? But what happens if 6 months from now, that platform starts to distribute podcasts widely with ads, and suddenly that entity is now making money potentially by distributing ads in your client's podcast. But because you granted exclusive distribution rights to that entity and you didn't negotiate any back end, if they ever start distributing ads, they have the ability to go do that. So always thinking about when you're negotiating either distribution deals or distribution provisions in the deal, not just what is the counterparty's distribution model today, but what might it be a year from now, 5 years from now? And if that changes and I've granted broad distribution rights, have I given the client an opportunity, or at least tried for the client to participate in those other revenue streams? So contractual specifics. So here I'll go back before. There's a lot of words on the screen, and this is just an example of some of the things that I've mentioned before about nuances that may come up specifically in the boilerplate, which, there can be a tendency to maybe, by the time you get to the end of the boilerplate, maybe it's like thinking this, either there's not going to be the ability to negotiate it or it's not going to matter. But again, the boilerplate tends to set out who indemnifies who's repping, warranting what. And so threading the needle there and making clear that your client's repping and warranting only the things that they should be based on what their responsibilities are is super important. So, for example, if you're representing the host, there's all kinds of things that the host is going to rep and warrant. What's on the screen more is if you represent the production company, what are the reps and warranties that you may want to get from the host so that the host can enter into the agreement, that there's nothing preventing them, that they're not going to in the future grant any rights that interfere with this agreement, that everything's going to be wholly original to the host. It's not up there now, but query whether you want the host to rep and warrant that they haven't used AI without getting your permission. That might come up. They'll typically rep and warrant if it's the 1, 2, 3, 4, fifth bullet point that the materials are not going to infringe on the production company's use of that what they deliver will not infringe on third-party rights. So that's important there, that it's not defaming anyone. So there's just a few examples of things that if you're representing the production company or the entity that's acquiring the rights, you might just be mindful of trying to include. Sorry, I lost that. There we go. Here, then we talk about, so before, if you look at the slide, we had the reps and warranties that the host would make, and then there's the indemnification. So if the host breaches one of the reps and warranties and you sue the host, then what have they agreed to do? And I highlighted defend there because that's not always in there, right? Do they agree to not just hold you harmless and cover the costs that you incur, but can you require them to defend, i.e., step into your shoes, take over the defense and have to deal with that? And I think there's sometimes a bit of a knee-jerk reaction that you put defend in there because you assume that it's going to be better, but maybe you don't want the host to necessarily defend because you don't want them to take over the defense because, you want to yourself or you're going to have better counsel. So you might put defend at your election. So it's very clear that they only defend if you want them to. It's not that as a condition to indemnifying you, they have to also have the opportunity to defend it themselves. So there's all kinds of things that you may want them to defend you against. And then I put there in yellow in little Roman numeral 2, do they defend and indemnify you, or at least indemnify you for things said by the people they invite on the show? Or have you added the guests to E&O insurance if we didn't talk about insurance? But that typically is also something that gets negotiated in the deals. Who's responsible for getting insurance? At what point in time? And you also, you make clear that you as the production company can compromise and decide to settle a claim at any time that you want. There's additional considerations if you're representing here the production company, or if you're representing the host, but, did the host contribute third-party materials, right? If it's about their book, is the host rep and warranting that they have all the rights they need to the book for you to make the podcast? Same with the title, right? Who came up with the title? Is it a pre-existing title? You have all the rights you could possibly need to the title. Are there prior agreements that are related to the podcast that need to be assigned to you? So lots of things to think about. And now flipping it to the other side is if you represent the host, what do you want the production company to indemnify you, right? Because if you're the host and you're, writing, maybe you're not even writing the scripts. Maybe the host is just really more of the voice of the show. And if your client is really the voice of the show and doesn't have as much say into the writing, is not clear on whether things have been reviewed or not, if your client, the host, gets sued because of something that was said on the podcast, but that they didn't have any control over that, it's maybe not the host. Maybe you're representing the talent in a scripted podcast, and the talent comes in, they read their lines, but they haven't written the script. They have no idea whether the script is maybe based on someone else and there's copyright infringement. So if you're, depending on the services your client is rendering, if they get dragged into a lawsuit for something they had no control over, are they being indemnified appropriately for that? So there's an example there of some language that you might have. And then the question is the second bullet point there is, when do you agree to defend the host, right? Because if you're the production company, are you going to step into the shoes of their counsel and actually defend the claim? Or are you only agreeing to indemnify them? And you'll see often the production companies or the buyers don't necessarily want to agree to defend. And there's a ton of qualifiers that are put to when they agree even to indemnify. Again, a lot of things here. So sticking to the idea that if you represent, this goes to threading the needle, like I said before, right? So in that first bullet point, if you represent the podcaster who's delivering the project to the buyer, the production company, let's say you represent the production company here, you want to exclude from the indemnification obligations of your client who's producing it all kinds of things, right? So if you see there, it's material that's supplied by the buyer, that's excluded, right? If you get in trouble because of what the buyer told you to put into the podcast, that's excluded from your indemnification obligations. If the buyer has acted in a way that's reckless or willful, that's excluded. Like I said, you see the note there. If the financier has final cut, then maybe if you add something that says, if you get in trouble for language that we said don't put that in, but because you had final cut, you won and you put it in, that's excluded from the scope of the things that will indemnify you. So it's, a lot of language there, and this is by no means the only way to do it, but it's just sort of things to think about as you're going through the agreement. Now, that was a lot of words, so we'll stick to clearance issues. So everything we spoke about before with how you might be brought to advise clients in, I'd say, a transactional way, whereas now what's coming up is your client is producing the podcast and you are brought on as clearance counsel to make sure that the podcast they put out there into the world is free and clear of legal claims, or at the very least, if they receive a legal claim, that they are going to be able to, get it thrown out on a motion to dismiss, or you're going to be able to write a very convincing letter, because there's never, the fact that you get it legally reviewed doesn't mean someone couldn't object. It just means that you've hopefully put the client in a position where if they do get it, there's not going to be a colorable claim that will be brought against your client. So what are the things you might be asked to review and advise on as an attorney? It's the script, potentially. It might be the audio cuts. It might be trailers. You might be reviewing promo copy, so what they're going to put on the Instagram posts. It might be the interviews themselves. I like to get involved, I think, as early as you can, the better, because if they've already gone through, recorded the script, they have the audio and have to go in and make changes to the audio based on problematic content, it's a lot more, it's more annoying for the client than you give them notes early on at the script. You go back and forth a few times and then they just record something that they know is going to be, fine and good to go. The only qualifier to that is if they're putting third-party material in, which we'll get to in a second. Where there's third-party material, you may need to actually listen to the audio to make sure that the way that the audio comes out is a fair use as well. And we'll get to fair use in a minute. Another way that, we can be helpful as attorneys here to our clients is not just reviewing, but anticipating. So if your client is, an experienced producer, that might not be an issue, but maybe the first few podcasts they'll produce, you run a producer training session where you give them rules of the road for what they, can and can't say, and what's defamatory, and where do the lines about privacy stand, and what kind of, best practices for news reporting and sourcing, and what does it mean to have a source that's on the record versus off the record, and all of those things you can go through with your clients before. And this, especially where it's what you call like an always on show, or if it's a daily show, a weekly show, where your client may just not have the budget to have every single episode reviewed by legal. So you tell them, okay, well, if you see XYZ, this is when you elevate it to legal, and these are the episodes that I should review. Um, Music comes up a lot in terms of content that's used, and it's important if you're licensing music and not fair using, which we'll get to in a second. But the licenses, you'll need both a license if it's for a song, both the master license for the use of the recording, and then the sync license to be able to use the recording in sync with the podcast. And then this next point is quite in the weeds, but there's also, public performance rights. And then and this really comes up if you're representing a client like a production company that's delivering the content to a large platform or a network, often the master license and the sync license won't include a buyout of the public performance rights. And so having clear in your agreement, like if you represent the production company with the platform, that typically the platform has an overall a deal with the performance rights organizations, and that they will cover those fees. So sometimes you'll have the language like I had on the screen, which makes clear that the buyer is going to be responsible for fees owed for public performance rights. Which if you don't have that and then you haven't bought them out and you said you would deliver a podcast that's fully cleared, that's where there's a disconnect. So licensing materials and fair use. This comes up all the time. When can you use third-party material without getting a license, and when should you get a license? So this comes up a lot with archival, right? Especially unscripted, I mean, both, but in unscripted shows where they're talking about, I don't know if it's a show that looks back on the music of the Rolling Stones. Are you licensing all of the music, or in some cases, are you going to be able to fair use it? And I'll turn to, fair use a bit more. The cover art, if you have all the agreements in place there, music I just spoke about. And so if you're not licensing and I actually thought I had more slides on this. I don't, but I'll speak to it briefly because I think it's important. If you're going to fair use material, which I won't get into detail because I'm sure a lot of people listening to this are familiar, but it basically means, it's an affirmative defense under copyright law, where even though you've not gotten permission from the copyright holder, the law recognizes that you've used the material in a way that there's a general public interest that you should be able to do that. And so the law permits it. And there's a number of factors. There's unfortunately no clear way to know whether something or not is fair use, because the courts look at 4 factors. They look at, the nature of the use, the nature of the underlying recording, how much of it was used, what's the effect on the market, the fact that you haven't licensed it, is it causing them harm? And most importantly, they look at, have you transformed the use? So if the original clips are news clips that are talking about I'm trying to not come up with a sad event. They're talking about the results of an election. And you're using those clips not to relay what the results were, but your podcast is actually about how the media has evolved and how different sectors of the media cover different topics, and you're using different clips to compare there. That's the use is different. The original use was to convey information, but you're using it here to comment on the different manner in which people report the news, different news organizations report the news, or music, for example, like the Rolling Stones. If you're using a part of the song Miss You and you're talking about a certain chord progression that was very unique to Mick Jagger, and then you cut to, a couple of seconds or just as long as you need of that chord projection for progression for your audience to understand what you're talking about, are you using no more than necessary? It's for a new use, right? The original use was entertainment, listening. The use now is not for that, but it's to illustrate and be commented on, and in the context of commentary, which is different. And judges apply this analysis in a very difficult way. And it's kind of unfortunate that fair use, which is meant to benefit people ends up actually requiring a lawyer to opine on whether something or not is fair use, but you're likely to be asked to help your clients figure that out often if they are asking you to do the legal review on their project. And if you are licensing the content, you want to, think about it's in the same way the guest releases, how I was saying, think about the potential restrictions that you're agreeing to with a guest and how their interview can be used. It's the same thing if you're licensing material. So if you're licensing material to put in your show or your client's show, is the term in perpetuity or is it limited? Because if it's limited, it means that in a year, you're going to need to renew it. And the truth is, sometimes your clients may not afford to be able to get a perpetual license. So they may have to license for a limited term. But if they do, the next best thing is to have a renewal option with a preset fee so that your client knows that every 5 years, if they got a 5-year license, they'll be able to renew at X rate. It's typically you won't get perpetual renewal options. It might be for 1 or 2, but at the very least, it gives you a bit of time. And the other thing is making sure, if you can be helpful to your client when they are licensing things that are for a limited term or for limited uses, that they're tracking that. Sometimes they'll have clearance charts and permissions grids that they'll ask you to help fill out because when they're delivering their show to the buyer, they need to let the buyer know. So yeah, typically in a license, those are the things that'll be limited. The term, the territory, is it worldwide, which for a podcast, you want it to be worldwide. And if there's any restrictions that only for one use, can you use it both from the podcast and in the trailer? Can you use it more than once in the podcast? Can you only use it in the podcast in its form? Or if a client wants to do one day an anthology of all their shows, is that a double use to have the right? So just making sure that if you are licensing content, you're tracking the terms of the licenses very clearly. ADA compliance, I put that there because it's important to be able to, you need to have the scripts that are available for your podcasts. And so just making sure that sometimes there'll be restrictions, like the talent won't want you to have the right to like have a transcript or to subtitle or something. And you have to remind them, like, I can't strike that language because the podcast has to be available. There has to be a transcript. And First Amendment considerations. So a lot of this is, when you're reviewing the script, it's separate from the copyright issue. Is my client going to get in trouble for what's being said in the podcast? And so defamation, privacy, news gathering, there's a little bit maybe sometimes that feeling that, oh, it's said in audio, it's said so quickly, it's okay, people aren't going to come after me. Maybe, but they do. I mean, there are definitely, you don't really see many. I don't know if there have been really any that have reached trial stage because often these things get settled. But very important to, what is said on a podcast is just as capable of being defamatory of what's written in an article or what's written in a book. So, if it's a podcast about, I don't know, a certain industry, or it's a podcast about, whether it's an entity or a person, making sure that anything that's a statement of fact that could be true or false, and that if it's false, could be defamatory. What's the sourcing there? Do you have more than one source? You don't always have to have more than one source, but what's the sourcing there? Have you reviewed the source? If the client had the show fact checked, and sort of understanding if you have a question and there's like the sources that are linked in the script, actually making sure that, because sometimes it just happens, right? You'll link a source thinking, but is it actually what's said in the source? For example, the complaint, if it says they were found liable or they, committed something, but actually you open the source and what the source is a complaint, and then you have to make clear, but the complaint alleged that, and just making sure often that the sources that you're provided by the client actually support the way that the client has interpreted what's in the source. So sort of going that extra step is going to be very helpful for many clients. And like I said before, on the record, off the record, that's important as well, because if the source is off the record and your client gets sued and they only had one source, that source is off the record. It's as if they didn't have a source because that source is off the record, which I don't know that people necessarily always realize. And then another thing that goes back to the guest releases, you may have guests that agree to participate on the condition of, not being named. And it's always important whenever I see in a script, so and so who will name X told us about, their first divorce. And then their voice is there. And so I'll always go back at the release and say, well, what exactly did you agree? Because if this person gave you an interview thinking you were going to use someone else's voice and you agreed you wouldn't identify them, not identifying someone is a very different agreement than saying you won't be named. Because obviously if you can't identify them, that probably means you can't use their voice. So being very specific about what you will and won't do with your sources and your interviewees is very important in that way. And so I think that basically takes us to the end of the presentation. And I noticed that there were some questions as we were going. So maybe Nina will turn to those.
Yeah, thank you so much for that presentation, Alexia. Really informative. And we can go ahead and jump into some of our audience questions.
Yeah,
Awesome.
great. So I'll take them in no particular order. That's fine.
Yeah, that works. You can, if you want to choose the ones you can, or I can read them to you, whatever your preference is.
Yeah, it's okay. I'll go through those. So, all right. So I'll try and take them somewhat in order. So if you, there's a question, if you decided to create a podcast yourself, what would be the first 5 to 10 steps that you would think about when in doing that? Sorry, I just lost it when you moved it. Okay. What would be the first 5 to 10 steps you would complete before starting your podcast? So that's a good question. I mean, you as an individual, I would think about there's a lot of different things. One, do you have an LLC set up? And are you, making this podcast through your LLC, which is a good thing to think about early, because if you messed up and get sued, at least the hope is that your personal assets and, you're not liable individually, but the LLC would be. So a lot of people will do that as a first step. Then in terms of the title, looking if there's other titles out there that are the same. Is it a title you want to put, before you go and invest a lot of resources and money behind a specific title, seeing if there's a competing show that exists out there, that's a good step. If you're anyone that you're working with, even if it's a friend, especially if it's a friend, have an agreement with, because if they're not employees, which they probably aren't, then, and they render services in connection with the podcast, whether that's compose and theme music, whether that's do the cover art, whether that's help you write scripts, whether that's editing, unless you have an agreement with them, their work is not work for hire. So having it be work for hire, meaning that you own all of it, will just make it much easier and be very important. Otherwise, they can potentially get in the way of you're exploiting all of the rights in the show. Making sure that depending on what kind of show it's going to be, think about how you're going to source it, how you're going to report it. If you want to register the copyright, you can only register the copyright for episodes in a batch before you release. Once you start to release, you have to register them one at a time. So maybe thinking about that. Yeah, a lot of potential steps to start, but I often think just having your paperwork in order. And then there's like technical things like finding a platform, all of that. But there's a lot of things I think in terms of starting that also, other from legal, just things to think about. Let's see so this is a sort of a good segue. There's a question, what provisions should be included in contracts to address potential disputes among disputes among podcast team members? So that's a great question because it's like I was saying, at some point, you typically only look at a contract when things go wrong. So it might be that it's co-hosts and one wants to keep making the show and the other one has that. Well, talk about that, right? If one doesn't want to, but the other one does, have you said that the party who wants to keep making the podcast can, but they'll pay a passive revenue share to the party that's out and they'll be able to keep doing it? Do they have the right to do that? What if there's a creative dispute? Whenever you put that all creative decisions will be mutually approved, what happens if there's a tie break, right? If you don't have a tie break, that technically means that until you make a mutual decision, you're stuck. So whenever you have mutual approval, having tie break mechanisms, thinking about what happens when one side wants to move forward and the other one doesn't, it's really like there's really those provisions. It's what happens after the term, who gets to make decisions in connection with the podcast, and it's often resolved by there's one side that'll be able to keep to make it, but there'll be some benefit to the other side, so they'll continue to participate somehow in the revenue. Other questions, do I tend to be involved with audio-based podcasts or video-based podcasts, or both? How would I revise my advice, if at all, for those who want to create video-based podcasts? That's a good question too. I mean, it comes up a lot. I think I wouldn't change the advice in the sense that when I draft an agreement, I would assume that at some point your client's going to want to have a video component. So even if they don't now, have that already, have that the podcast is going to be primarily audio, but can be synced with visual materials. Have that it can be distributed on both audio and audiovisual platforms, so that at the point at which you do want to have a video component, you don't have to reopen the deal. So it's just sort of think about that. And especially nowadays, podcasts are, YouTube is a really popular distribution mechanism for podcasts, in large part because it's easy with discoverability. So if you like search for something on YouTube, a podcast there, it's going to be, it's very difficult sometimes to find a podcast on other platforms. So more and more people are putting their podcasts both on audio platforms and YouTube for discoverability reasons. So thinking about that is important as well, and making sure you have the rights to both sync your podcast with visual elements, but also distribute the podcast on audiovisual platforms is important. Do I tend to represent the host or the production company of a podcast? If so, why? Are there particular advantages to specializing in representing either the host or the production company? So I tend to represent mostly production companies. That's the way that my practice has evolved. And you will find that most attorneys do one or the other, or one reason, which is that you're conflicted out often otherwise, right? Because if you're representing the hosts who are working with production companies or platforms, it's very difficult you kind of have to pick one, because otherwise with conflict, you're just too often conflicted out. And I don't really know where there are specific advantages. I think you have talent attorneys that tend to represent hosts and other attorneys who represent more platforms. I think it's also a question of preference. Do you prefer working with production company? Do you prefer working with the individual talent? Do you feel like you're doing more the good work for the creator by representing the host? Some people, it's a lot of personal preference too. I personally like working with production companies because you stay with them across the slate of shows and you work on a bunch of different shows with them. So yeah, I don't think there's a right or wrong. It just depends the way you developed your practice. There's another question about guest releases, whether there's a specific case I've handled in which I've represented the creator or the financier of the podcast, and I found myself dealing with the attorney for a guest, and the back and forth became particularly fraught. What did I do to alleviate the guest attorney's concerns? That's a great question. The answer is yes, all the time. Every single time you put paperwork in front of a guest, you get a lot of comments back, which like stepping aside and just being human about it for a second makes sense, right? If you get a piece of paper that says you can use my name, likeness, and voice in any manner, however, in anything, and I waive all rights to complain, I'm not famous and I wouldn't like to sign that. So I understand that you get pushback and you get pushback about that. You get pushback, they want it to be narrowly tailored in one episode only, no other uses. They want approval over promo. They want to be able to review. And, in terms of, you say, how'd you handle it? Often when I get asked by the talent attorney, we want a chance to review how we sound in the podcast. To me, I'm like, I can't do that because it's a question of editorial independence, right? Like, and one, you know, the show needs to be perceived as something that the client's made that's editorially independent. And you don't want also your client to be seen to have, basically dictated how they're going to sound in the show. Sometimes you say, like, I'm really sorry, I can't do that. But listen, what I can tell you is I'm the production counsel. I review everything that gets released. There's no interest, we have no interest to make the guests look bad. If if the guest says something problematic, it's a problem for us because we're publishing it. We're the party with the deep pocket. So even though we're asking you to say that you're not going to say anything defamatory, rest assured, the goal isn't to rely on that indemnification because we're going to be on the hook if something happens. Listen to other episodes we've done. You see how the guests come across. We've got a shared interest in the guest looking really great. You can agree and say, look, I can't say I won't, edit the interview in a way that's negative because that's not a legal standard. But I can agree, obviously, that we're not going to, edit the interview in a way that's defamatory of you. And I think often like the back and forth, which when you get a red line where you're going to land. And so I think sometimes the most efficient way, rather than giving you piecemeal the pieces you can, you're like, listen, I hear you. I saw the comments. Here's a responsive red line. It's the best I can do on all these points. If you've got further questions, let's talk about it and just sort of cut through it. And, it'll be better for your client. They're going to have less fees. So I think just cutting through and often getting on a call helps, getting the other side's attorney on a call, providing reasons for why you can't do something. Because often if you just send back a red line that says no, 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 and they send that back to their client, the talent, that's going to be much harder than if you send back either within the email or in the document notes that explain why. Because the lawyer's going to be able to also forward that to their client and say, listen, look, I really tried. These are the reasons. Like, are you comfortable us closing? So it's sort of like help them help their client too. The last question here, have I found that the laws of a particular state are more favorable for this industry than other states, like the laws of Delaware? That's also a really good question. So the governing law clause is, it's not that it's more favorable specifically for the podcast industry. It's just that, for example, in New York has a lot of experience with publishing generally. The judges are experienced. New York tends to be a little bit more publisher friendly than necessarily talent friendly, whereas California, which has very robust rights of publicity laws, everything is, very more talent friendly. So it depends, right? If your talent typically wants California law to apply, the publisher might want New York law to apply. The parole evidence rule works differently in California and in New York. So it depends what side you're on, but yes, like deciding the governing law, deliberately and mindfully is important. And I think that brings us to the end of the questions. Yeah, thanks for all the great questions.
Yeah, thank you for your insight, Alexia. And as Alexia said, thank you all for submitting your questions. We're almost out of time for today, so I'm going to go ahead and hand things back over to my colleague, Marina, to wrap things up.
Yes. Thank you, Nina. Thanks, Alexia. Thanks to all of you for being here today. There was some really fantastic questions and lots of engagement, so we're very glad to see that. Today's presentation did help illustrate that podcasting is, one of these new digital mediums that we're all consuming. And so if you're interested in how Digital Society can kind of help your law firm grow your practice, if you're looking to increase that online visibility, I did want to make sure that everybody here today was aware of Justia Marketing Solutions. There's a lot of information out there on our website about that at marketing.justia.com. But we do offer digital marketing solutions to help lawyers grow their practice, connect with more clients, and increase their online visibility. So check those out. Feel free to submit a contact form or give us a call if you have questions. We offer free consultations and can talk with you about how Justia's marketing solutions can help your practice grow. Now, on to those housekeeping things I referenced at the beginning of the presentation. Now, for those CLE attendees who are here today, as I mentioned before, you do have to be a Justia Connect Pro member to get CLE credit. So if you are not already a Justia Connect Pro, you can head over to pro.justia.com, and there you'll be able to upgrade to the Justia Connect Pro membership. There are very affordable payment plans, either monthly or yearly. So check that out if you're interested in CLE credit. And then, of course, if you have any questions, any trouble with any of that, I encourage you to reach out. You can get to our team at support.justia.com, and we'd be happy to explain all of this again. We'd be happy to answer any questions you have. Without further ado, I will say thank you all again for being here today. I hope to see you on Monday, and have a fantastic weekend.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.